Assalamualaikum warahmatullahi wabarakatuh. Welcome back. We are still discussing exemption clause. So another important rule or principle relating to exemption clause is that liability may be excluded for negligent conduct or act. I mean, here in cases whenever it involves negligence. So we need to see whether exemption clause is still enforceable, operative or not. So this is the case. Sekawan Gad Sdn Bhd and Tong Guan Sdn Bhd reported in year 1995 in MLJ. It involved a contract in writing. So this is appeal case. So appellant was Sekawan, okay, the Sekawan Gad, Sekawan. So they agreed to provide security services at the premises, okay, of the respondent, Tong Guan. So they provide the service to Tong Guan. Tong Guan was the appellant. And then one day a theft occurred at the premises. So it resulted in the loss of Tong Guan's goods. So now Tong Guan sued Sekawan because Sekawan was the one to provide the security services. So Tong Guan sued Sekawan for breach of contract. And alternatively, they also sued for negligence. And then Sekawan relied on the exemption clause in the contract, which provided that it was not liable for any loss suffered by Tong Guan, okay, unless the loss was solely caused by the negligence of Sekawan's employee. Okay, that's the exclusion clause here. Right. And Sekawan also argued that the loss was in fact caused by the negligence of Tong Guan's own guard, okay, who was not at the premises on the night in question, although he was on duty. But Sekawan, despite the argument, there's no evidence actually produced in the court to prove that Tong Guan's guard was the negligent, not their own guard that they provided to Tong Guan. So the session court judge disregarded both the issues of exemption clause and negligence, okay, on the ground that they were not pleaded in Sekawan's statement of defense, okay, and because of that, here this is actually the procedural matter, okay, the technical issue, technical aspect. So the court allowed Tong Guan's claim, but Sekawan appealed against the session court's decision, and at the appeal level here, the court still dismissed the appeal because as the issues of exemption clause and negligence of Tong Guan's employee were not pleaded in Sekawan's statement of defense, so the court held that the session court judge was correct in disregarding them. And it's too late for Sekawan to raise the issues on appeal. And obiter, the remark by the court here, even if the exemption clause could be raised as a defense, okay, the burden was on Sekawan to show that it applied here. Okay, so that's basically the observation by the court. Okay, this is another subtopic. What if the exemption clause is too wide? Okay, it's so wide and general. Okay, the rule is that exemption clause, however wide and general, it does not exonerate the respondents from the burden of proving that the damages caused to the car. This is from this case, Chin Hoi Nan. The damage to the car were not due to their negligence and misconduct. So the party must show that they had exercised due diligence and care in the handling of the car. If they were negligent in the first place, so exemption clause could not protect them. That's the rule, which was that's the ratio from this case. Chin Hoi Nan and Comprehensive Auto Restoration Service Syndrome here. Okay, let's have a look at the facts here. The appellant had agreed to have his car waxed and polished by the respondent. And after leaving his car with respondent, appellant, the car owner, took a receipt to claim the car later. And at the back of the receipt was an exemption clause stating that the respondent were not liable for any loss or damage to the car. The exclusion from liability. And the car was actually damaged while in the care of the respondent. So now appellant filed a suit claiming damages for negligence. And then the learned magistrate dismissed the suit on the ground that the exemption clause at the back of the receipt exonerated the respondent from liability. I mean, here the court just give effect to the exemption clause. I mean, there's no liability because of this, the existence of the exemption clause here. But the appellant appealed against the decision. So now, what's the issue before the judge? Okay, whether exemption clause could absolve the respondent from blame for the damages to the said car can be let go. Okay, I mean, can the respondent be absolved from liability because of this exemption clause? So the court held that however wide it is, okay, but it cannot really exonerate, okay, absolve respondent from burden of proving that the damages caused to the car were not due to their negligence. Meaning that here, if they were negligent, then exemption clause shouldn't cannot protect them here. Okay. And respondent had not adduced any evidence that they had exercised due care and diligence. They could be protected if they have exercised due care and diligence, but in this case, there's no such evidence. But the court found that there was ample evidence, okay, to show that respondent had been negligent, okay, when their employee had involved the car in an accident while driving the car in the basement car park. Okay, so that's how the court applied the exemption clause. Okay, so it wasn't enforceable in this case. In some situation, okay, knowledge of the notice or condition may be presumed. Okay, here sometimes because the party might argue that, oh, we don't know about it, okay, about the existence of the exemption clause. For example, in the case of Malaysian Airlines, Berhad and Malini Nader, 1986. So in 1976, okay, the second respondent, she booked at Kuala Lumpur for a return ticket for first respondent to depart from Heathrow Airport, London for Kuala Lumpur. And the last confirmation of flight was made 2 weeks before the scheduled flight. And the air ticket was issued less than 10 days before the flight. So that was the day before we have all these online things here, okay? Way back in year 1976. So the first respondent was told that there was no seat, okay, for her when she checked in at the airport. Yeah, she had been confirmed with the ticket, but there's no seat available. So eventually, by arrangement made by appellant, so the first respondent left London on the following day. So a day late lah, basically a delay of 1 day, following day on another flight. Okay, now respondent sued for damages for breach of contract and negligence. And appellant, Malaysian Airlines, rely on Article 19 of the Warsaw Convention, not sure that I pronounce it correctly, which states that the carrier, okay, airlines, is liable for damage occasioned by delay in the carriage by air of passenger. And the convention, that convention here, especially chapter 3, okay, relevant part of the convention, liability, it talks about liability of the carrier, and Article 19, it says that the carrier is liable for damage occasioned by delay in the carriage by air of passengers, luggage, or goods. So the court held that, this is observation by the court, appellant's decision not to carry the first respondent on the flight was fully covered by condition number 9, printed on the air ticket issued to the first respondent. Okay, it doesn't amount to breach of contract, and then the court held that respondent, the passenger, ought to have known the said condition as it was printed on the tickets, and then the airlines was fully protected here. Okay, and confirmation of seat must be understood to be subject to the said condition, even though the seat was confirmed. But again, it depends, okay, whether there was seat or not here. Okay, no claim can succeed on the basis of confirmation of seat, especially in a case where such confirmation were made before the issue of the ticket. Okay, that's the decision. Okay, this is another subtopic here. Construction of exemption clause, exemption or exclusion clause. Construction is the interpretation, how the court interpret, how the court give proper meaning in order to give the effect, okay, of the relevant exemption clause or exclusion clause here. We have the rule named as contra, or known as contra proferentum rule. It means the words of documents are to be taken strongly against the one who puts forward. The one who put in the exemption clause, okay, wherever possible, the court will construe in favor of the other party, the weaker party, usually, the one who doesn't have the opportunity to bargain about the exemption clause. So normally, the court will construe, will interpret the words in any written documents in favor of the recipient of the document, not the one who put forward the clauses, because the clauses is meant to protect them from liability. Okay, so the reason for this is that the party putting forward the document is normally able to impose onerous, okay, or unfair terms, exempting himself wholly or partly from his liability under the contract. So the words of exemption clause must be very clear and exactly cover the liability that it is sought to exclude. Okay, if it's not clear, then the court will apply this contra proferentum rule. Okay, the court will construe forcibly with force. Okay? The words of a written document against the party putting forward the document in cases of ambiguity, or where the scope or meaning of the clause is open to construction. Whenever the clause is very clear, then there's no, I mean, the rule cannot be applied. Whenever it contains ambiguity, or whenever it is possible to interpret two ways, then the court will apply this contra proferentum rule in order to protect the weaker party usually. Okay? We have the case of Syarikat Lee, Hanks, Emberhard, and Port Swettenham Authority. So the plaintiff or the appellant in this case is decision by federal court. The appellant claim for the sum of 936 being the value of one case of lockets lost while in the custody of the defendant. And federal court held that the contra proferentum rule should apply, and the court referred to construe, to interpret rules 91, 91 clause 1 of the Port Swettenham Authority bylaws, okay, 1965. Because why? It contains ambiguity. Okay, the very fact that serious controversial, okay, has arisen as to whether the rule has placed the onus of proof on the bailer or bailee to show how the goods came to be lost clearly demonstrate that it suffers from ambiguity. I mean that here, the fact that the parties argue, okay, whether the onus of proof, is it on the bailer, is it on the bailee, and then how it was lost basically. So meaning that here, this provision, this part of the rule here, it contains ambiguity. So the court, federal court applied this contra proferentum rule, okay, in this particular case. And then the court observed that, federal court observed that the onus, the burden of proof lies on the authority, okay, Port Swettenham Authority, to show that it has taken all reasonable care of the goods, okay, that the loss thereof occurred in circumstances which showed no lack of care on its part. Okay, must prove to the court. Okay, I mean that here it happened, but without lack of care whatsoever. Otherwise, they should be liable. Okay, the last part of our topic here for contents of contract is effects of fundamental breach on exclusion clause. But in order to know the effect, we must know what is fundamental breach of contract. So fundamental breach, as the name says, okay, it goes without saying, fundamental. So a breach by one party, by the one who breached the contract, which is sufficiently serious, very serious in nature, to entitle the other party not merely to claim damages, okay, but the other party can has the option, okay, to elect to strip himself of discharge from further performance under the contract. Then this is called what we call as fundamental breach. Breach which is so fundamental. Sometimes breach is just a minor breach here, but this one serious, okay, very fundamental. It affects the whole contract, the whole performance. And the rule is that where this is taken from this case, Hua Chia Lin and Malin Jaya Melaka Semhat 1996, where there was a fundamental breach which justified a rescission on the part of the plaintiff to rescind the contract when the house he bought was delivered not as what he had bargained for. And here he purchased a house, but when he received it, okay, when he was given the key to it, it was not the house that he intended to buy. Okay, I mean here it is different in description and it wasn't in the proper condition here. All right, let's go to the facts of the case. On 11 September 1984, plaintiff entered into agreement with the developer, okay, to purchase a single-story terrace house. The price was 60,950. And a notice dated June 1986, that one 2 years later, okay, was sent to plaintiff by the developer, okay, to take delivery of vacant possession. In 1987, a year later, plaintiff orally complained to defendant regarding the defects found in the building, and remedial works were done, but in an unsatisfactory manner. I mean, here they try to remedy, they try to rectify, okay, repair the house, but it was not done properly. Okay, it was done, but not up to satisfaction of the plaintiff. So now plaintiff asking for a claim to refund, okay, to return the house, doesn't want to proceed with the purchase. So the court allowed plaintiff claim and the court ordered a refund of the purchase price, okay, because from the evidence, okay, produced in the court, fundamental breach had occurred because the building that was delivered to the plaintiff in 1986 was not what they had bargained for. The one that they had signed, okay, it has to be a proper house, okay, completed house in a good condition, but it was not the one. So the evidence adduced clearly showed that the said building, when delivered to plaintiff, was in a terrible shape, okay, that required massive. It's not just a minor remedial works here, massive remedial works, okay, massive repairing works. And actually it had to be rebuilt. So it's very, very terrible. So since what was delivered was not what had been agreed upon, the breach was a breach that went to the root of the contract. So this is an example of fundamental breach. So even, I mean, exemption clause cannot prevail over this fundamental breach. So again, whether or not exemption clause can protect a party to a contract, it depends on the construction of the contract. Because again, whenever we talk about contract law, it goes back to the freedom of the parties to negotiate the terms between them, okay, to balance the risk whatsoever. So when the parties were on equal, especially if the parties were on equal bargaining power, okay, they should be free to apportion the risk among them, between them, okay, as they thought fit, and to make provision for their respective risks according to the terms they choose to agree. So the court will interfere with the freedom of contract whenever they are on equal bargaining power. For example, House of Lords case, decision in the case of Photo Production Limited and Securico Transport Limited. Here, security agreement included an exclusion clause, okay, under the effects that under no circumstances, very wide, okay, here, extensive. Under no circumstances shall the company, Securico, be responsible for any injurious or acts or default by an employee of the company. And actually, it involved negligence, okay, on the part of the employee, and Securico argued, okay, that they were being protected under this exemption clause, and they have actually agreed, okay, to insert the clause in their agreement, and they had discussed about it, okay. So it's about, I mean, when they entered into contract, they agreed to insert this particular clauses. So the court actually, this is observation, okay, in this case, the invalidity of exclusion clause where a fundamental breach had occurred was discarded. Instead, okay, here in this case, exemption clause are to be construed by the same rules of contract interpretation. Okay, it doesn't matter whether it is fundamental breach or not. Okay, the court just give the effect to the exemption clause. So whether or not liability was excluded was to be decided simply on the construction of the contract. So this is actually different approach lah by House of Lords. The House of Lords made it clear. Okay. And the court found that the clause to be quite clear, okay, and unambiguous, and found that it precluded the liability of the security company. So there's no liability at all on the part of the security company. And in deciding this case, actually, House of Lords reaffirmed their decision in the Swiss Atlantic Society Diamond SA and NV. This is earlier case in 1967, whereas this case in the year 1980. Okay, and these two cases, I mean, Swiss Atlantic and photo production cases here, it formed a definitive statement of the law up to the unfair contracts term 1977. So they codified the whole thing, okay, to cover whenever it involves unfair contract terms. But in Malaysia, we don't have this equivalent statute in Malaysia. Okay, so what's the position in Malaysia? So we have a recent case reported in 2019, quite recent here, in relation to exclusion clause in Malaysia. The case is CIMB Bank and Anthony Lawrence Burke and another, decision by Federal Court. So Federal Court held that exclusion clause in the loan agreement was void and unenforceable. Okay, because why? It was on agreement in restraint of legal proceedings under Section 29 of Contracts Act. And therefore, it was contrary to public policy. So it wasn't enforceable. It wasn't valid in that particular case here. So it's different approach. And after all, we don't have this unfair contract terms in Malaysia. Okay? So the court rely on the interpretation of the clause, and the court also cross-referred to Section 29 of Contracts Act. And the court held that the exclusion clause was void and unenforceable in that particular case. And this is the analysis, okay, explanation from the case. As a matter of public policy, absolute exemption clause, such as clause 12 of the loan agreement, was patently unfair and unjust. So the court looked at the clause and the court concluded, oh, this is very, very unfair. Okay? for public policy, meaning here the court refer to public policy. And then federal court recognize that the bargaining power of the borrowers and the bank are different. They are not on equal bargaining power. Okay. And then the court reason that actually this is something which is unconscionable. We call it unconscionable bargain. Okay. Unconscionable for the bank to seek refuge behind such clause. And in that sense, okay, actually the bank, okay, the party abuse the freedom of contract. Okay, whereas it should be done fairly. Okay, that's the decision by federal court. So I think different approach compared to House of Lords. Okay, that's all. We conclude the whole topic, okay, for contents of the contract. Okay, let me stop share. And we have also concluded the whole syllabus, okay, for Law 1210. So I think that's all. All right. Assalamualaikum warahmatullahi wabarakatuh.